80 words per minute for 10 minutes. 5 seconds more. Start. The petitioner, while the present writ petition has assailed the impugned award dated 8th October 2015 of the Labour Court in a claim filed by the claimant, that is, respondent, herein challenging the termination of his services with a prayer for reinstatement, continuity in service, full back wages, and all consequential benefits and litigation expenses on the ground that the petitioner herein had illegally terminated his services, whereby void the impugned award, the claim of the respondent herein to the present writ petition had been partially allowed. Void order dated 16th February 2016, the operation of the impugned award had been stayed. The parties to the writ petition were also referred to the Lok Adalat for an amicable settlement, which, however, could not be resolved as none put in appearance on behalf of the management. When the matter was taken up for hearing again, it was submitted on behalf of the respondent that the respondent had since superannuated and that his son has expired, and he sought an expeditious hearing, and that the relief of the reinstatement in service had already become infructuous. The prayer was thus confined to the 50% back wages from the date of the termination till the date of the superannuation. The respondent joined the services of the petitioner as a driver for heavy motor vehicle services and had been in service with the petitioner for more than 25 years, but that his HMV driving license expired on 1st January 2007 and was not renewed for the reasons that the respondent herein was involved in a fatal accident case and was facing trial. The respondent herein is stated to have attained the age of 55 years in March 2011. In terms of an order, the drivers of the petitioner could get the benefit of the enhanced retirement age subject to their being found fit in every respect after a thorough medical examination by the medical officer, but if they were found unfit by such medical examination, they were to be retired from the services of the undertaking without any notice. Void show cause notices issued by the petitioner to the respondent, he was called upon to present the renewed HMV license, or else the petitioner stated that it would not be possible to continue the services of the respondent herein, and that further action according to rules would be taken against him. The respondent filed his letter before the Labour Court, admitted that his HMV driving license had expired on 30th January 2007 and stated that he was facing trial in an FIR and that he had applied for renewal of his HMV license, but the concerned department till then had not renewed his license. It was thus submitted by the petitioner that the respondent, having failed to produce his HMV driving license, the petitioner was left with no option but to compulsorily retire the petitioner. The respondent herein challenged the compulsory retirement order before the Assistant Labour Commissioner, and conciliation proceedings were taken up which were not fruitful, and thus the conciliation officer issued certificate to approach the Labour Court for adjudication of the industrial dispute, pursuant to which the respondent filed his statement of claim dated 21st March 2014 before the Labour Court against the petitioner, seeking withdrawal of his retirement and sought relief of his reinstatement. An opportunity was granted to either side by the Labour Court to lead evidence, and after arguments were addressed, the Labour Court held that the respondent was entitled to the reinstatement in service with continuity in service and all consequential benefits, and also held him entitled to 50% back wages from the date of the termination of his services. Whereas on behalf of the petitioner, it was urged that the impugned award of the Labour Court be set aside, and on behalf of the respondent, it was urged that the order of reinstatement in service with continuity in service and all consequential benefits and 50% back wages from the date of the termination of his services be upheld and be directed to be implemented. On a consideration of the available record and submissions made by either side, and taking into account that his license had admittedly expired on 31st July 2007 and was not renewed by the Transport Authority, and that the petitioner gave ample opportunity to the respondent vide show cause notices, he cannot be granted any benefit for continuing in service beyond the age of 55 years. In these circumstances, it is held that there was no illegality in the termination of the services of the respondent. In view thereof, the impugned award of the Labour Court is thus set aside. However, as was submitted during the course of the arguments addressed on behalf of the petitioner, the respondent would be entitled to all the retirement benefits due to him from the date of his retirement, that is 31st March 2013. The petition is disposed of accordingly.